easy. For the second case we want to talk about is the lawsuit about the national emergency declaration by the president. He's being sued, I think, by 16 states. We have with us, as always, she doesn't even leave anymore. She just actually sleeps in this studio. Jenna Ellis, the constitutional law attorney. She contributes to the Washington Examiner, the Federalist, and someplace called the Daily Wire. But that's just, when she's slumming, basically. She's a frequent guest on Fox and the author of The Legal Basis for a Moral Constitution, a guide for Christians to understand America's current constitutional crisis. And Jenna, I hope you noticed we're back in the studio. We're back. They've actually brought us out of bin Laden's cave back to the studio.
Which is great, and the couches are so much more comfortable there. So I really appreciate that we're back in studio.
It's also not 30 degrees and it stinks. It really stank in there. And I told the guys, don't worry, we're leaving the studio, but we're leaving the outside studio, but we'll always have our mesothelioma or whatever.
There you go. That's another potential lawsuit. So there you go. Yeah.
Exactly. So, let's talk about this. It's like 16 states are suing the president over his declaration of a national emergency. Do they have a case?
No, absolutely not.
Okay.
And what's so sad about this is that the states are really filing this, and this was instigated by the Attorney General of California, who is known to be a liberal activist and has lost actually a lot of cases recently. The NIFLA case that went in front of the Supreme Court, that was about California's controversial free speech case for crisis pregnancy centers. That one, NIFLA versus Becerra, that one specifically was another case that he wanted to just take and was absolutely activist of California. And so at his instigation, now he's roped in about 16 states for this lawsuit. But the federal government and the state governments have a separation of powers pursuant to the Constitution. And that's the way that our constitutional republic works. And so if the states don't like the fact that the president can declare a national emergency pursuant to authority that Congress has given them, their remedy is to go and lobby Congress. And this is why, by the way, I think that the 17th Amendment should be repealed and state legislatures should be able to appoint and then recall senators. And that was one of the ways of having that check and balance on congressional authority. But because of the 17th Amendment, we don't have that anymore. But the remedy here is not a lawsuit. It's to go through the viable constitutional mechanism.
So you're not arguing about the whether the national emergency is constitutional. You're arguing that they have no standing. But don't they have standing if he's going to build part of the wall in California? I mean, can't they say, well, our land is going to suffer and there's going to be problems here?
I don't think that they have standing even in that instance. And what about, so Colorado, my home state, is joining that, and we're certainly not a border state. So what standing would they have? So this is it's just a political maneuver here. But even for the states that are on the border, this is again why immigration and naturalization, as well as border security and military operations, are specifically given to the federal government, because the states are part of the United States of America, and they still are under Article 4 when they join the Union, and they're still subservient and under the U.S. Constitution as supreme law of the land. And so they don't have any standing to challenge what subject matter our U.S. Constitution provides to the federal government to determine. If they don't like policy, well, they can go just like any other regular citizen can and go and lobby Congress and go through those mechanisms. But they can't challenge something simply because they don't like the policy and say that it's unconstitutional. Because remember, the liberals use that term unconstitutional to mean I don't like your policy. The actual definition of it means, can the federal government use its specific limited authority in this particular way? And all of the law and the Constitution says absolutely.
So about this law, the emergency declaration, every emergency declaration up till now, I mean, not everyone, but most of them have been about stopping tyrants and hostile countries from moving funds around. This is really different. I mean, it's different in kind, and it feels like he is expanding, maybe not the law, maybe not the written law, but it feels like he's expanding the use of it. Is there any problem constitutionally in your mind? I mean, if the lawsuit goes forward and they say, oh, well, California does have standing. There was a very funny clip of Trump saying, yeah, they'll sue, and then we'll go to this court and that court. Finally, we'll go to the Supreme Court and then we'll win. Will he win at the Supreme Court level?
He should. If this case actually reaches the merits and they don't dismiss it on a procedural issue like standing and just say, you can't sue on this basis anyway. If the Supreme Court reaches the merits, then absolutely. I mean, a declaration of national emergency pursuant to the 1976 law, as well as others, that Congress never said first, here is the limits of what you can and can't declare a national emergency on. That's implicit in the Constitution anyway, what powers are actually given to the federal government. So when Nancy Pelosi and others are saying, well, all of a sudden, this will open the floodgates that he can declare, a future president can declare a national emergency on gun control or healthcare or climate change. Well, that's just ridiculous, because none of those subject matters are given to the federal government as limited powers to do anything about anyway. So we don't have that problem. But even if we reach the merits here, we still have precedent from President Reagan as well as President George W. Bush right after 9/11, temporarily declaring a national emergency following 9/11. So we have some analogous precedent, but we also have the law that if Congress wants to change, it absolutely can. And I think that that's a legitimate question for Congress to consider, but not after the fact and not just because they don't like this particular president.
Yeah, the New York Times had a really interesting line. I mean, I don't think that they were lying. I just think that they were wrong, where they said basically Congress could override what he's doing, which they just can't. I mean, Congress cannot veto the president. The president can veto Congress.
Right. And there's actually I believe it's a 1981 Supreme Court case that dealt with this very question, that said if Congress has delegated specific limited authority to the president under their own acts, then if the president decides to use that power that's been delegated in a certain policy way, Congress then can't go back and veto it because they're basically circumventing their own law that they created. So that we already have Supreme Court precedent on that level as well. And I wrote a piece just yesterday in Washington Examiner that discusses this, and the headline is, sorry, Democrats, President Trump isn't creating this president that's just going to open the floodgates. But I think people really need to understand the Constitution in context and understand what a declaration of national emergency is and what it is not, and also what an executive order is and what it is not.
So my last question, just as one conservative to another, setting the law aside, does it bother you to see Trump use the executive power in this way, and compare it for a minute to Obama's executive orders? I mean, it is different in kind from Obama's executive orders, but it kind of bothers me in the same way, just instinctively.
Well, it doesn't bother me because he's actually using his authority pursuant to a subject matter that is given to the federal government, where President Obama was issuing executive orders on education, on social justice issues, on things that absolutely were outside the scope of what the federal government is vested with in power. And so when conservatives are objecting to President Obama, we're not objecting to the use of executive orders, period. We're objecting to what is he actually doing with the executive order. And here it is very different in kind because the subject matter is different. National security, border protection, defense spending, those are all things that the federal government constitutionally has power to determine. So it doesn't bother me.
Jenna Ellis, always great to see you, the author of The Legal Basis for a Moral Constitution. You can see her just about everywhere, but why would you when you can always see her here, I think.
Absolutely. And great to see you again, Drew.
It's always great to talk to you. Thanks, Jenna.